Welcome back to Native American Studies 299-499 here at Sitting Bull College, our Tribal Sovereignty and Contemporary Supreme Court Jurisprudence Special Topics Survey course. I'm your instructor, Kara Damari, and today we are looking at Washington versus the United States, a 2018 U.S. Supreme Court case. As usual, we will be going through the parties, the issues, the procedural posture, and the rule and holding. And this case is a little bit different than the other cases we have looked at so far because the Supreme Court didn't proffer a long written opinion as we've seen in other cases. They were actually divided. They were divided 4-4, and we'll talk about the reasons for that later on. And they effectively just affirmed the lower court's ruling, therefore. So it was an equally divided court. But let's start out by talking about the parties. So on one side, we have the state of Washington. Now, the state of Washington, as you can see from their logo, was, or their seal, I should say, was established as part of the United States, or got its statehood in 1889. As you know from maps, it's on the sort of most northwestern part of the lower 48 present-day United States. And it was, named for George Washington. It was part of the Washington Territory, which the British Empire ceded in the mid 1800s, 1840s, as also sort of as part of the Oregon Treaty, which settled the dispute that was surrounding the boundaries there. On the west side of present-day Washington State is the Pacific Ocean, and then to the north is the Canadian province of British Columbia. So it's the 18th largest landmass state, and in the top 20 of the most populous states too. And then on the other side, we have the United States. Now, if you look to the briefing for this case, you look to the opinion, you'll see that it is, in fact, the United States and then a number of different tribes. And I'll talk about why those parties are included as such. So very frequently we see in Supreme Court cases, we see just one name as the respondent or as the petitioner. Let's remember, what is the respondent? Who's the respondent here? Do we remember? Washington would be the petitioner, right? They are the first named party. And so they are the ones who petitioned the US Supreme Court via a writ of certiorari in order for the US Supreme Court to decide, and in this case, in fact, decide in favor of hearing this case, all right? They are the petitioner. As the petitioner, they file their brief first, similar to sort of oral argument. They're also in oral argument before the US Supreme Court will speak first, and then they'll be able to reserve time in oral argument and speak again at the end of the oral argument, which if you listen to this case on Oye, they did. Whereas the respondent will sort of come second. The respondent is the one who frequently won at the prior court level. So at the appellate court level, the appellate court likely decided in the respondent's favor, and that's why the petitioner is further appealing to the US Supreme Court in that way. And the respondent in this case is the United States, but also all of these tribes. Now, some of you might know why the United States is named in addition to these tribes. If you do, you're maybe a step ahead of the game. But as part of the trust responsibility of the United States government, the federal trust responsibility, the United States provides litigation support for tribes. This is part of that federally trust responsibility. It's a legally enforceable fiduciary obligation, as the Pleasant Point tribal government mentions here. I think they had a nice summary, so I included this for you all. And so the United States Supreme Court has sort of confirmed through previous litigation that this does entail legal duties. All right, there are moral obligations. There's the fulfillment of understandings and expectations that have arisen, as they say here, over the entire course of the relationship between the United States and those tribes. And the federal government basically has this duty to protect and recognize the independence of tribal government, authority, and advance tribal sovereignty and protect tribal property interests. So we've got a lot of those ideas implicated here in this case, as we'll see in a second. But an important thing to note is that one of their responsibilities in the trust relationship is this obligation to represent tribes in litigation. So frequently you'll see that the United States government is named in addition to tribes, or they submit an amicus brief, or they otherwise are involved with lawsuits on behalf of tribes, even when the alternate party is a state or even a faction of the United States government. So it's uh, an interesting kind of dissonance there. But you'll note also that, as Sharon O'Brien in this book, American Indian Tribal Governments, noted, that despite the responsibility, this kind of legal aid is not always forthcoming, and it's also not always of adequate quality. As she notes here, tribes have to convince either the AG's office or the Justice Department or the Solicitor's office for the DOI, the Department of Interior, to file a suit on their behalf or to join them in that way. And those offices have a wide discretion in deciding which cases to pursue. Or I don't know if they necessarily have a wide discretion, as she says here, but they've sort of taken a wide discretion at times. And so, there is some, despite this being part of the trust relationship, there have been over time substantial failings with this part of the trust relationship. But that is why the United States is on the other side of the V from Washington here, and as the first named party, they're included in the name of this case, Washington versus the United States. Who are the tribes on the other side of the B? Well, many of them are tribes from near present-day Washington state, all right? Here's a list of some of the tribes that are in that area. Not all these tribes were involved in the lawsuits, in this lawsuit. And I have a picture here. You can see present-day reservation areas near the present-day state of Washington. And a lot of these are coastal peoples. And I want to take a second to actually talk about the importance of salmon. So we're headed into this lawsuit, and this lawsuit has to do with uh, barriers, these things called culverts, which are blocking barriers, which are blocking. Oh, I'm not going to buy any, but images. Basically blocking the ability of salmon. So you can see some culverts, maybe it's a little bit easier for salmon to get through, but other culverts, it's certainly not intuitive and maybe not even possible for salmon to get through. And over time, these culverts have accounted for a substantial amount of salmon, the salmon degradation potentially. And there's a lot of debate. If you got to listen to the US Supreme Court oral argument, there's a lot of debate about, what constitutes substantial. There's one justice who says, well, in securities law, 5% is enormous, and it is certainly substantial. All right. So depending on the amounts, but in the, I don't know if they were the appendices or the additional documents which went to the Supreme Court for this case, there's a lot of information from different biologists and ecologists about the state of salmon in Washington state, the current situation of salmon in Washington state, and how these culverts have potentially degraded or even destroyed certain salmon populations or whatever. So you can find that in the additional information that comes along with this case. But let's talk about salmon for a second and the importance of salmon in tribal cultures. We'll go to the Columbia River Intertribal Fish Commission. Some of these tribes were involved in this lawsuit. And we can see here that, and remember, when we studied the Bay Mills case, I believe, we looked at, there was a tribal fishing commission in that area as well that we looked at, and I think you had a homework assignment on, or a quiz assignment on. So here in the Columbia River Intertribal Fish Commission area, and we can actually, let's look at the Columbia River. So maps, let's just go to Columbia River. Let's go over there for a second. All right, so let's see here. can see we're in present day Washington State area, the area of all these tribes. We're down by the Yakima Reservation, and this river right here, which runs through, is the Columbia River, and its offshoots provide for an enormous amount of tribal water supply and fish and other things. So we can see this is the river that is coming down along here, goes through Spokane, goes by Colville, and continues on and has these offshoots, connects up with the Snake River here, and then, obviously continues down through and past Portland into the Pacific. So a big water system. And as many of you know, if you took an environmental science course, for example, these water systems have many offshoots and are responsible for a huge amount of how any of these lands can be used, and the ability for people to live in these areas and everything else. So you can do your own kind of looking at this river if you'd like to. So back to the importance of salmon in tribal culture, we see that salmon are listed as sort of among the first foods. And salmon have a place in tribal culture, and especially in the cultures of these regions, that is not just for providing a means of sustenance. Salmon are also deeply incorporated into the tribal spiritual and cultural identities of this region. As it notes here, over a dozen of the longhouses, we see a picture of a longhouse down here on the right. Over a dozen of the longhouses and churches still use salmon for their annual religious, or for their, not annual, but for their religious services. The annual salmon run is celebrated by the tribes. Tribal members still prefer fishing as a livelihood. So salmon are so much more than simply either a means of sustenance or even a means of occupation, for example. Salmon are deeply embedded within the cultures of these tribes. You'll note here, and this is the Columbia River Intertribal Official Commission, and you'll note what they say last year: without salmon returning to our rivers and streams, we would cease to be Indian people. So this is how important these tribes consider salmon to them. All right. And you can see some words from tribal leaders. My strength is from the fish. My blood is from the fish. From the roots and berries, the fish and game are the essence of my life. I was not brought from a foreign country and did not come here. I was put here by the Creator, right? We see that's in the early 1900s, the chief of the Yakima tribe, putting those words out. We also see one of the Umatilla tribal members, the importance of the first salmon ceremony has to do with the celebration of life, as of the salmon as subsistence, meaning that the Indians depend upon the salmon for their living. And the annual celebration is just that. It's an appreciation that the salmon are coming back. It is, again, the natural law, the cycle of life. It's the way things are. And if there was no water, there would be no salmon, and there would be no cycle, no food, and the Indian people respected accordingly. Okay, so we get the indication from this Intertribal Fish Commission just of how important salmon are to these tribes and to the tribes of the region. All right, and you can see, you can feel free to explore that site on your own. And I want to take that one step further, and we'll just look at some pictures. This is part of the Museum of the American Indian at the Smithsonian. That's what that SI stands for, I believe. And they've put together some cultural resources. And so I think these are pretty interesting. This talks about the Pacific Coast region and describes Native nations of this area as they self-define themselves as a salmon people, right? As salmon is an important gift from the Creator. It's honored in ceremonies and throughout the Northwest. Salmon is a unifying factor. So we see here, I'm going to look at a couple of these pictures just to give you a sense of why it's so important. Here's salmon roasting going on at the Makah Days, which is a period of celebration for Makah citizens to honor thousands of years of customs and traditions, and the anniversary of becoming US citizens in 1924 under the American Indian Citizenship Act. So we see some salmon being roasted. Let's go to another picture. Here we see during the 1950s, the same sort of cedar skewers used to roast salmon, right? So this same practice has been going on for quite a while. This is also uh, macaw. A member of the Macaw Nation says, "We've been out on boats all of our lives. My dad was a fisherman. He was young. He grew up here on the water. We grew up in boats, on boats. It seemed like we were fishing everywhere we went. We'd always throw a hook in the water somewhere, whether it's a lake or along the river or wherever we went." And we see some examples of these hooks. This is a hook and line method. It's the Smithsonian and this project denotes that it reflects the sustainable practice of taking enough fish for a family or community while leaving enough healthy, sustainable amount of fish in the ocean to spawn. Spawn in fish language means to, uh, lay eggs and have them fertilized or whatever and migrate. And then we also see here one of the nets. This was a net that was made to target specific types and sizes of fish. It's a Quileute net, which is a tribe of the region. And actually, we can go on and see in the Puget Sound, we also see people still doing this similar sort of roasting over fire salmon tradition. These are fillets. Let's see here. We've got another photo of some women around the 1950s. Uh, they're preparing salmon in such a way which is free of sort of added fats that pan frying produces, right? Researchers estimate that as late as the 1940s, annual consumption of salmon was over 320 pounds per person. So people ate a lot of salmon, right? And we see a Lummi tribal member saying, "My dad instilled in me how important the fish was. We spent many hours in the water, and that's how I related to myself as a strong person through fishing. I know that I'm the person I am today because of fishing." And we see also a boat culture in this region, right? These are shovel nose canoes that are sort of a flat bottom boat carved out from a single tree. They're made for shallow waters and speed and agility, as it says here. And people have started sort of making more of these boats. We see another one of these boats here. And we'll go on and just look at the Columbia River area too. Here we see some netting practices going on. Salilo, this idea of the echo of the water on the rocks.
Sahapton.
In the language of the area. And fish being at some points so abundant previously that you could walk out onto the that people said that you could walk across the river on their backs. Okay, and so even we see here that it's noted that other Native nations, including Lakota and Dakota people from the present day Dakotas, actually gathered at these falls to trade goods and fish. All right, so these had importance to not only the nations of this region, but to nations across the continent. We see here a Yakima tribal member fishing in one of the tributaries of the Columbia River. I talked about sort of water systems and watersheds, whatever. A tributary is a smaller sort of river that comes, does it come into the water system or out of it? It comes into the water system, I believe. So this is one of the potentially coming down from a mountain from snow melt and flowing into the Columbia River water system. So this is a tributary of that. And this is the Klickitat River, and it's one of these tributaries. And Yakima tribal members gather there and do some dip netting. So what we see in this photo is a gentleman with a dip net, which is a certain fish catching practice. There are also these set nets, as we see here, that you'd actually put into the water and trap salmon in the water. And one of the benefits of doing it this way is that the salmon actually, are in there and stay in the water and stay cool and even stay alive until they're taken out. That's a practice that you see throughout the Northwest and even in present day Alaska. We see a Colville tribal member talking about how salmon has always been essential to our lives. We all had jobs to do, and most of them centered around salmon. Salmon provided everything they needed to live. All their religion and food was salmon. It was the basis for everything. All right. So really, like I stressed the sort of salmon facts and the salmon history to give you a sense of just how important uh, salmon and fishing is to the peoples of this region. All right. And so that's why uh, when uh, when treaty making was going on in this region, and we see here Isaac Stevens, uh, fishing and salmon became integral parts of these treaties. Isaac Stevens was a governor of the territory of Washington for a couple of years and became a representative to the House of Representatives. But he also did he did a lot of treaty making, and he did this during his time as a governor. He was a governor from 1853 to 1857 for the territory of Washington, and made treaties in 1854, the Treaty of Medicine Creek, in 1855, the Treaty with the Macaw, the Treaty of Hellgate, the Treaty of Point Elliott, the Treaty of Point No Point, the Quinault Treaty, the Treaty of Walla Walla. So many treaties Isaac Stevens made with tribes in this region. And about him, he was sort of you can get those sense here, but he was a very short man. I think he was only a little bit over 5 feet tall, and he I think he was probably from the East Coast, and had moved out west, and had become involved with this treaty making. And there's a lot of not so great history about him sort of forcing tribes in Washington Territory to sign these treaties through intimidating them, through threatening, through using troops to wage brutal campaigns against them, such as one winter campaign against the Yakima, and even executing. He executed one chief, which even eventually led him to be removed from his post. All right, so this was a brutal man, and the man, though, who was responsible for many of these treaties. I think it's important to note that, because when we're looking at the language in these treaties, I don't want to actually, I'll move away from his picture, but when we're looking at the language in these treaties, we have to realize that these treaties were written really to take, not were written to take things away from the tribes, but they were written from the perspective of this guy who was trying to give the tribes as little as possible. And so when they did reserve rights, or when there are, even if they didn't directly say that they reserved them, what this treaty doesn't take away, like that would suggest that should be respected, right? Because he was obviously on a path to make these treaties in such a way that they accounted for all the control that the state did want, and so anything not included or whatever else is probably appropriately considered retained by the tribes, and especially those things that were explicitly written in as being retained by the tribes. All right, so this particular case, takes us, we start looking at this case in 2013. This is our procedural posture, this is our case history that we're looking at now, and we've talked about before that these cases stretch on for a number of years, right? This is one of the extreme difficulties in this type of litigation, especially for tribes, right? Many tribes have attorneys which are not, who don't stay around for a long time, or tribes have different tribal councils which turn over and whatever, and to continue on with litigation for this number of years. And this is actually fairly quick litigation compared to much other litigation, but to do this from, say, 2013, when it's originally filed in the Western District for the state of Washington, and then to have it appealed to the Ninth Circuit, and then have it sort of appealed in different ways, and then appealed further for an en banc decision, which is denied, and then to in 2017, be applying for a writ of certiorari, the state of Washington still appealing this case, right? Can really, it really costs a lot of money. It costs a lot of tribal time and energy, and these are issues that tribes would suggest are already included within the treaties, and why they need to be relitigated, I think, is it just puts more of a burden on tribes oftentimes. Anyway, this case makes it eventually to the U.S. Supreme Court after the state of Washington appeals from the Ninth Circuit decision. The Ninth Circuit upheld, I believe, the district court decision, or mainly did, and then the state of Washington appealed it further to the U.S. Supreme Court. I want to focus a little bit today on the arguments that were being made at the U.S. Supreme Court, and then also the amicus briefs that were submitted as well. We've talked about these briefs, amicus or amicus briefs that are oftentimes submitted, and we'll go through a little bit of those today. But so we first see the kind of title headings from the petitioners when they submitted their brief to the U.S. Supreme Court. First, I should note that when they apply for a writ of certiorari, they have to submit briefing then, but then when they actually go before the Supreme Court, they submit additional briefing, and their real briefing. Their initial briefing for the writ of certiorari is specific for that purpose, whereas their briefing for the U.S. Supreme Court is on the basis of the facts of the case or whatever else, or on the basis of the arguments of the case, I should say. So we see here the brief for the petitioners. Who are the petitioners again? Right, Washington State, right? They are the ones who've petitioned for the writ of certiorari to get to the U.S. Supreme Court, and here we are at the U.S. Supreme Court. And so they basically go through in their brief historical runs and treaty negotiations. They talk about salmon runs declining over time, usually due to federal actions. The federal actions they're describing here are federal dams. Now, federal dams are not implicated in this case, and federal dams have historically had some, on occasion had like salmon ladders and have had other things, but ultimately this suit wasn't against the federal government. The suit was against the state of Washington and these culverts in particular. So the state of Washington, you see here, is kind of trying to defray that and put some of that on put some of the decline of salmon onto federal action such as damming. They talk about Washington State's efforts to preserve and protect the salmons, and they look at the treaties, prior decisions regarding the treaties. So their main argument, and I want to lay this out for you all. Oops, let me indent this once so you can have a little bit clearer picture of this. Oops, I don't know if I can do that cleanly. Maybe not. All right, I'll just do it like that. So when you are looking at briefing, if you want to look at briefs for any of these cases, let me know and I'll provide you with copies or some sort of access for you to get your own copies. When you are looking at briefing, though, you'll see that parties break down briefs into certain subject headings, and these headings are enormously helpful for kind of overviewing an argument. So it's really important to follow kind of that structure when writing a brief, for example, but then also, to help you when reading this kind of brief, because the broader heading is sort of the argument that the party is going to be making, and then the subheadings are supportive facts for that argument. So just like when you're writing an essay, you have like your thesis statement and your body, which has the supporting facts, right? But in each one of those body paragraphs, you have a thesis statement at the beginning. So too do court briefs frequently have a main sort of heading which summarizes what's going to be argued, and then sort of subsequent subheadings which summarize the parts that combine to create the argument, and then having sort of body information included in there about for example, the facts that support this, or the other case history that supports this, and these smaller supportive pillars within this broader scheme. So we see the state of Washington arguing here that the treaties guarantee important rights, but not a particular standard of living. And so this goes to uh, something that we hear discussed in the oral argument quite a bit, which is that whether or not the standard of living is required to basically be enough to provide for tribes through some sort of working type situation, or other sort of other standard of living things like that. And we see that they're arguing that the inferred right is unsupported by treaty language, that it's unsupported by history and understanding, and that it's unsupported by precedent, that furthermore it's unnecessary and that it's unworkable, right? And why would you want to include all of these arguments? It's almost, as they say in the law for other things, sort of a use it or lose it approach, right? If the Supreme Court is going through your briefing, and say it might not agree with you about this being unsupported by treaty language or the history, but say it's like, okay, well, this is unsupported by precedent, for example, or I think it's less likely that the Supreme Court would necessarily find that it was unworkable, because if something was being argued at this stage, like there would likely be some potential remedy that would come out of this. All right, so that seems a little bit of a superfluous argument, but I guess you make all the arguments that you can. We see that the state should be allowed to raise equitable defenses against the federal government, and by that, Washington is suggesting that the U.S. government, as it noted sort of above, has some sort of role in the decline of salmon populations, and that therefore the state should be able to sort of blame the government for some of this. And part of the other reason they say they should be able to do this is because they had gotten sort of this broad, I believe it is a sort of a fairly broad, I don't know if it's the EPA or an EPA type permit, which allowed these culverts in general or something like that. And so they were trying to put it on this, I don't know if it's some sort of Clean Water Act permit or something like that, but that permit's purpose was, as the tribe will later argue, or as the federal government will, or as the US will later argue, wasn't actually to for the purposes maybe that the state is alleging here. Um, and so they also say that equitable defenses like those limit remedies, but they don't limit treaty rights. And they say that the Supreme Court should consider equitable defenses here because precedential other cases have suggested that they should, that there's some precedential value to that, or whatever. I guess not really precedential value, but like previous cases which seem to suggest that. And then they say their third kind of point is that a broad system-wide injunction ignores the court's legal rules limiting injunctive relief. And so they say that injunctive relief should be more specific, and in fact that requiring the states to replace culverts won't have an impact, and that it's going to cost too much money, and that there's no real evidence that culverts can chain tribal harvests, and that it forces basically Washington State to fix this whole thing, which Washington State alleges has been impacted by the federal government. All right. So this is what's going on in Washington State's brief. And why this is important is we do hear, and you can listen to the oral argument on OIA, oia.org. We've talked about that a number of times, and there's a link within your MySBCs. You can listen to the oral argument, but because we don't have an opinion here that the Supreme Court publishes, it's nice to be able to read what was submitted to the Supreme Court. And so that's why we're going through this week, we're going to go through these briefs like we're doing now. All right, so in front of us now, we see the brief for the United States. And this is for the United States as part of their what? Yes, as part of their trust responsibility, right? To provide this litigation support. And we see that they're arguing that under the Stevens Treaties, the right of taking fish includes a right against substantial degradation of tribal fisheries. All right, so within those Stevens Treaties, we remember that guy, within those Stevens Treaties, we have a reserved, or not, I mean, we have a clear right to take fish, right of taking fish. All right, and the the U.S. argues that the U.S. on as the respondent, right, against Washington State, argues that treaty signatories intended to protect tribal fisheries from obstructions that would degrade the resource, right? Because how can you have, for example, a ability to have a right of taking fish if someone else has destroyed the entire fish population or something like that, right? They also, like as part of that argument, argue that contemporaneous sources of law protected fisheries against obstructions. All right, so other laws that were going on around that time. So when the Stevens treaties were being signed in the 1850s, you look at other sources of law, and they do protect against obstructions. So when we're looking at one of these canons of construction for Indian law is looking at how the tribes would have interpreted things when the treaties were being signed. All right. And the reason why we do that, and the reasons are multifold, but one reason why we do that is that, the government had a system of treaty making. It had all these, these treaty makers and lawyers and whoever else, on its side, and then it would meet with a member of a tribal council or a tribal chief, and they might not have any support on that side. So we construe uh, treaties from, especially from this period, like how the Native people would have interpreted them at the time, and that is a fundamental canon of Indian law, treaty construction, or Indian. I guess I don't know if I phrased that correctly, but it is something that is done consistently, and that all courts do consistently in terms of interpreting treaties, to construe them in favor of how the tribe would have understood them, because the tribes, and also let's remember that even the linguistic differences, right? I mean, that these treaties are in English; they're not written in tribal languages mostly, right? And so whether or not the members of the tribal council or of the tribal chief, or the tribal elders, or whoever was engaged in this treaty making process with the United States even understood the language, means that we really need to make sure that we're looking at how tribes understood them. And in fact, though, here we see the U.S. saying that, even from how the U.S. understood it, which is what they're writing in the English versions of these treaties, how the U.S. understood it, there would have been other laws at that time which protected fisheries from obstructions. And what they're talking about is throughout the U.S., throughout what was the United States at that time, there is a series of laws which talk about uh, the any sort of obstruction of a river, as being a nuisance. All right. So we have these, like, even in other areas of the United States, and even in this area of the United States, we see other laws around this time and other court decisions, showing that those obstructions are a kind of nuisance, and in fact that people can get legal remedies from them even at the time of this treaty being signed. All right. The U.S. also argues that precedents of the Supreme Court confirm that the right of taking fish includes protection against substantial depletion of the fisheries. And this is something we've seen the Supreme Court and lower courts say time and time again, that if in order to have a right to take fish, there needs to be this protection. Otherwise, it's a taking, and tribes should be compensated. We see that they argue that the state of Washington is mischaracterizing the decisions regarding the tribe's minimum standard of living. So that's sort of the minimum standard that we talked about before, in terms of ability to work in this way or whatever else, and that the Washington state's arguments concerning interpretation of the treaties are unpersuasive, and so that they shouldn't be regarded there. They also argue that the courts below properly rejected the state's equitable defenses. So the courts below properly said that Washington state couldn't try to put all of this on the federal government. And they say that the injunction provides appropriate relief to redress the treaty violation. So basically, that the states replacing barrier culverts will in fact have a substantial impact, that the record has ample evidence that culverts have affected these salmon harvest, that nothing in the record suggests that the states the state is correct about better spending funds on other salmon recovery efforts, and then also that the district court found correctly that when you balance out the equities, so when you balancing out the equities is you're looking at one thing on one side and you're looking at something else on the other side, right? And balancing just like in a scale. Um, a remedy for the state's treaty violations is correct. All right, so that's what the United States is arguing. And on behalf of the tribal respondents, there's also a brief submitted which argues sort of similar things to what the United States is arguing, but a little bit more specific from the tribe's position. Let me try to indent those for you all too. Basically, they say that the state of Washington's barrier culverts violate the treaties by blocking the passage of the fish, right, and substantially degrading the fishery. All right, this is a right of taking secured by the treaties to protect the fisheries. The district court correctly found that the state was in violation of those treaties. The moderate living standard is misplaced, and the state fails to identify any treaty interpretation that would protect the fishery from destruction without also requiring affirmance here. Without also requiring that this ability to protect the degradation in this way be affirmed. The district court correctly dismissed the state of Washington's substantial equitable defense, which we've mentioned before, and that the tribe is also arguing this, as the United States did. And then also that Washington's fact-specific criticisms of the injunction lack merit. And what they're talking about here is, if you did listen to that oral argument within OYA, you heard a lot of argument, but a lot of the justices asking questions, I should say, in the argument between the petitioner's attorney and even between the respondent's attorney about specific facts that one side or the other had argued. And for example, what constituted substantial, as I mentioned earlier, like what number constituted substantial. We hear a lot of time, these are only 1 hour arguments, and we hear a lot of time devoted to that. All right, and Washington State maybe doesn't clarify what it means there. So they talk about how the record, the tribes talk about how the record shows a clear connection between the culverts and their impact on salmon, that the state, that the district court, in fact, gave the state a lot of flexibility to prioritize culvert repairs. So we can just consider sort of this, right, as against the state's arguments, right, that these funds could be better spent elsewhere or something, right? And we say they actually did give them a lot of priority. And in oral argument, I believe it's also mentioned that the state of Washington brings up sort of the amount of money that this is going to cost, and the respondent, the tribes, and the United States basically say, yes, this is going to cost some money, but it is ultimately like 0.5% of the state's annual transportation budget or something like that. I forget the exact language, but you can listen to that within the oral argument. So this is what people do in legal cases, right? You argue from the best position of your client, and so you're going to hear arguments on both sides, and you can think about why it's important to even pre-address what the other side might be saying, right? And so even if it isn't, even if you might think like, oh, why do the tribal respondents even have to talk about, that there's no basis to reverse or that whatever? And it's because you're effectively getting ahead of what the other side is saying. And that's a strategy that you should probably use in not just assignments related to legal things, but you want to address even in other research papers. And maybe you've done this in other classes here at Sitting Bull, addressing potential counter arguments, right? This is a real tool to use when doing a research paper, which shows that you're aware of the broader picture, and that while that you have considered these things, that you haven't just decided on one way forward and gone blindly ahead without looking at all sides of these issues, and that given your look at all sides of these issues, you come out in the position that you're coming out in. And I think that is a smart way, obviously, for these briefs to be written, but also is a way to make sure to write your own kind of briefs, and not necessarily briefs, but like your own research papers, right? So part of what these part of what I'm trying to do here by showing you some of these brief arguments is to show you kind of the structure of some of these arguments where we have, similar to any research paper, a main sort of thesis statement and then subsequent parts, and then those are broken down with supportive facts and examples and analogies and whatever, and then you know including yeah, focusing on including even some counter arguments to potential to show your expansive knowledge on the subject and uh, to suggest why you're heading in a certain direction. And so I think those are smart things to consider. Next, we're going to look at some of the amicus briefs. And so, actually, before we get there, I suppose we'll look at this is the brief for the tribal respondents. This is some language that comes out of the initial statement within that brief, I believe, and basically just talking about how tribes of this area made a bargain with the United States in the 1850s. They said they would cede large amounts of their land, or in treat for large amounts of their land, as long as they could keep in perpetuity the right of taking fish at all usual and accustomed stations. This is language that comes up in many of these Stevens treaties, all right, in common with the citizens of the territory. Fisheries mean something, as we mentioned, spiritually as well as materially, right? They signed these treaties securing that as part of the bargain. And let's be clear, these treaties, weren't designed to favor tribes, right? Like, we know about the history of the sky, like these weren't, necessarily friendly tribes. And so when this language was included, we have to know that, I mean, this was extremely important to the tribes. And when they signed that, this was part of that. The tribal respondents argue that their rights not secure, that the state of Washington has redirected salmon-bearing streams through man-made culverts under state roads, and many of these culverts are impassable to salmon. We saw pictures of culverts earlier, because even though since before the treaties, Washington law has required any structure, and so this would be even into maybe territorial Washington law, has required any structure in a salmon-bearing stream to allow the fish to pass. So the Washington state, the tribe was arguing, even had, laws on its books which required that salmon be able to pass through these culverts, and yet culverts were still being constructed. All right, now this is the start of this sort of a strong basis for a lawsuit, right? Is that somebody has a duty to do something, and it's even a legally enforceable duty, and they're not doing it, right? And they've got a duty for several reasons. They've got a duty because it's in these treaties, but they've also even got a duty under their own state law, all right? And so this is what the tribe is arguing. The state has known this for decades, and it would have, taken, if they were just responding to it at their own rate, it would take kind of an extremely enormous amount of time. And the tribes also even say that the injunction doesn't do anything more than necessary to remedy the blockages that violate the treaties. The state of Washington has argued that the treaties give the tribes no protection against having their fishery choked off. You could block every salmon stream in the Sound, they mean the Puget Sound, I believe, and the state of Washington says, Your Honor, the treaties would not prohibit that. So think about this language in context of the right of, the treaties do say the right of taking fish at all usual and accustomed grounds and stations, right? And the state of Washington arguing here that, in fact, the treaties would not prohibit the state just basically getting rid of that right, which is specifically mentioned in the treaties. And so they take what the tribe calls an absolutionist position, right? And try to blame the federal government. We see that substantially, or not substantially, we see that repeatedly. But basically that the United States never actually, like these, for example, these clean water permits or whatever, weren't actually saying that the culverts were suitable for fish passage or legally required in that way. And so, and then they've also, they're also arguing that the state of Washington has shown no abuse of discretion or anything else. On the other side, we see the petitioner, this is in their reply brief. So they submit an initial brief, and I put the dates on here for that reason. They submit the initial brief, and let's say they did that in February of 2018. Then in March, the United States and the tribes submit their briefs as respondents. And then, just like an oral argument, the petitioner has this ability to come around and maybe submit a reply brief. Sometimes maybe tribes do too, I'm not sure, but they submit a reply brief here. And the state of Washington tries to argue that treaty interpretation should be the same going forward from the beginning, and that you can see here that uh, if the court remands, which means if the court sends it back, the Supreme Court sends it back to the Ninth Circuit or the lower court, that it should consider, adding in these equitable defenses. And so it's still sort of trying to say that and modifying the injunction, and that kind of thing. So those are our arguments. Now, those are submitted to the Supreme Court in these briefs, okay? And you can find oftentimes copies of these briefs online. Turtle Talk does a really good job of publishing these briefs for Indian law cases. If you want to look on there, we've talked about that before. But in addition to these briefs, you also have other groups which are submitting briefs on behalf of the parties, and they're doing that. These are amicus briefs, sort of amicus, as you might know if you've got any, like language interest, and you see that word AMI, or if you've got any sort of French language knowledge or other language knowledge, that's sort of a friend brief, right? Like amicus is sort of friends, and friends of the court briefs are in fact what these are. And these briefs are created to provide the sort of tertiary information that the court might need in order to understand an issue. Now, when the Supreme Court hears a case, you have, these 9 justices, or even 8 justices in this case, and we'll talk about why that is again. I haven't forgotten that. We'll talk about that in a second, or in a minute, or in 5 minutes. You see that other groups are trying to provide the court with a broader array of information around these particular issues. And that is extremely helpful to the US Supreme Court, okay? Because they get the briefs from the petitioner and the respondent, but they might still not be entirely familiar with this particular area of law or these kinds of facts, right? Like the United States Supreme Court has some smart people on there, but do they know exactly about, fisheries ecology in the state of Washington? They probably don't, right? And do they know about even the history of the law of barrier culverts or obstructions? Like that might, like even those specific points of law, might not be sort of, immediate to their minds, and might not have been an might not be easily searchable. Others might not have written information on it or whatever else. So these friends of the court in these amicus briefs submit briefs either on behalf of the petitioner or the respondent, which elucidate some of these issues, or further provide the history and the background of some of these issues, so that the Supreme Court may look to those in addition to its briefs if it has any further questions or wants any other clarification. All right, so we see here some of the amici, the friends of the court who are supporting the respondent, supporting the United States and the tribes. We see that this includes the tribes of Warm Springs Reservation of Oregon, of Umatilla, of Nez Perce, and then we also see that some Washington state government, like state officials and then local officials, current and former, are writing on behalf of the tribes and of the US as well. All right, so that's helpful because they might have further information to how the policy of Washington state has been over the years. We see here they're attesting that leadership is required, that rather than fighting over what they should do, the state should be joining local and tribal officials in rolling up their sleeves and spending these limited efforts in order to save the salmon. And why might they be arguing this? Well, as we talked about before, this case has gone on a long time, right? It's taken a lot of resources to go on. And one of the arguments of the petitioners of Washington state has been that, this sort of precious funds argument, or these other arguments related to, other people, should be responsible for defraying some of these costs or whatever. And so we see here some officials in the state of Washington, locally and at the state level, saying, in fact, like, if we want to be efficient, and if we want to all accomplish the same result of protecting the salmon, which we might want to do at a state level and a local level as well, then we need to be doing it not like this. We see a brief from law professors talking about the histories of culverts and of obstructions in rivers, right? And then also how that relates to Indian law and how these treaties are interpreted, that kind of thing, right? And so they're filing this brief. It says to explain the development of English common law rules. And we'll remember when they talk about English common law, why is that important for the United States? Why can you remember? We have talked about this before, but like, what does common law have to do with modern American law? Uh, well, a lot of the modern American legal system was founded off of the common law system that comes from England, right? And when we talk about common law, what do we mean? In common law, we mean a series of laws that are that are sometimes created by precedent, right? Um, and so common law is differentiated from statutory law because it's derived from these precedents that are, judicial or customary, rather than necessarily always by statutes. Remember, let's say like statutes means like actual written down laws and codes and that type of things, right? So English law evolved as law that was adopted and modified, over the years into this sort of common law system. And while statutory law can run aside common law, statutory law in the common law system generally provides the basic principles, and then the interpretation is done through this common law lens now. That's how common law has shifted into the US system. Other countries don't necessarily use common law. Some countries are really based on a statutory system, but it's almost a combination of the two now. However, back when these treaties were being signed in the 1850s, and then even earlier, the United States, we did see, on behalf of tribes, like them operating in this area where the United States had taken a lot of this common law system from England, and many of the laws that were in the early courts of the United States of America were really derived out of laws that had been on the books in England. All right. So, in fact, if you read this brief, for example, you'll see that a lot of the early American case law that's cited, and even the statutes in certain areas and whatever else, that prevented, for example, obstruction, due to or that provided remedies for obstruction to rivers that prevented people from catching fish or from salmon from getting through or that type of thing. So we do see that, that history there. Let's see here. All right. So we see some of those amicus curiae. I've got another page of those. Also on behalf of the tribes and of the US is a former governor of the state of Washington. All right. So he comes in, he decides that it's important enough for him to step up in this case on behalf of the tribes in the state of Washington and on behalf, of the US here, and say that he was, he's served on these various like electrical power and conservation councils, and that he's served in positions where he's had a responsibility to protect and mitigate and the destruction of wildlife and resources, and enhance fish and wildlife resources within this exact area, and that also that he was a senator, right? And as a senator, served on the Senate Energy and Natural Resources Committee and that type of thing, and was also vice chairman of the Select Committee on Indian Affairs. So I pulled for you some little blurbs from their Amicus Briefs where it just talks about why they are submitting a brief. I didn't go through and say exactly what their briefs are saying. You're welcome to have access to any of those. I'll help you out with that. But these are reasons why these are individuals who the Supreme Court may look to interpret, or to understand, not necessarily to interpret, but to understand more of the history of what's going on in this case, or these underlying issues, not underlying issues, or these sort of other, I don't know, basic facts that the Supreme Court justices might not be generally aware. They're not part of sort of general knowledge, unless you have spent a long time in one of these positions or focusing on these issues as these individuals have. We also see some fishermen's associations submitting on behalf, and then the NCAI and some other tribes also submitting. And on the other side, we see amicus briefs submitted in support of the petitioner, in support of Washington State. Very frequently, you'll see other states supporting a state through amicus briefs, and so we do see that here with some other states. Let me see here: Kansas, Louisiana, some other states, and then we even see, let's see here, different industry associations, home building, real estate, paper association, right? A Pacific Legal Foundation. Now it's important to note that like names of things don't necessarily equate to what they are, right? And so, you can do research onto who any of these bodies are. But the state of Washington also has a bunch of briefs that it submits, in support of its positions. Not in support of its positions, in clarification of its positions. All right, so we're at the Supreme Court level now, and as we see here, Justice Kennedy learns that while he was a Ninth Circuit Court of Appeals judge, so as you know, as you may know, one way that you can get to the U.S. Supreme Court is, say, for example, you're a Ninth Circuit judge and you're appointed by the president to the U.S. Supreme Court. You can be appointed when you're not a Ninth Circuit judge or when you're not even a Court of Appeals judge, but frequently we see the president at the time when there is an empty Supreme Court seat picking from an appellate level judge. Why might that be? Well, it makes sense, right? Because they have had experience, up to the highest level apart from the U.S. Supreme Court of judging that they can have. All right. And so, in fact, Justice Kennedy had been a Court of Appeals judge for the Ninth Circuit, which is the circuit that we're looking at here. And he had found out that he had participated in an earlier phase of this case. All right. And we didn't go into the long history of this case going back into the 1980s and I think even into the 1970s. So even though I did talk about how it was a long case proceeding up from district court in 2013 to 2018 by some standards, that was actually quite short. But actually there was some underlying issues here which were in cases back into the 1980s and I believe into the 1970s. And so in one of these cases, Justice Kennedy had actually determined, or one of his, or the clerk of the court or whoever had determined that he'd actually been a part of that, and he chose to recuse himself on that basis. He decided that he would not continue to participate in that case because he had previous exposure to it and because there was therefore some sort of conflict of interest. All right, because when you're reviewing things at the Supreme Court level, you're reviewing them as to what is provided. And if you've had, say, substantial additional information, you might feel as though there's some sort of conflict of interest or otherwise decide to recuse yourself. And so Justice Kennedy steps out for this case. And whereas the Supreme Court has 9 members when it's full, we now have 8 members. And those 8 members in this case ultimately find on a 4-4 basis that they don't have a decision in this case. All right, and when they do that, they submit some language that basically says they are affirming the decision of the previous court by a equally divided court, and that's it. That's all the opinion, as you likely saw in your MySBC says. And so the justices don't actually publish an opinion in this case. And when they do that, when they affirm the judgment of the equally divided court, then we go back down to that Ninth Circuit Court opinion. All right, and we have a couple Ninth Circuit Court opinions in this case because we have the regular opinion, then we also have or we have one of the opinions, but then we also have like an en banc denial to rehear the case, that kind of thing. But they're looking back to the Supreme Court's or to the Ninth Circuit's holding that supports the district court's determination that barrier culverts that the state of Washington had used when it made these roads over streams did violate the Stevens Treaties. So at the end of the day, we do have a holding from the US Supreme Court that the Stevens Treaties were violated by these culverts, which hindered salmon from swimming upstream to spawn, okay? And that when the court, in fact, had ordered the state to, what part of what the lower court had done is it had ordered the state to make a list of which culverts it owned within areas covered by the treaties and to fix or remove them over time, okay? And by affirming this, basically to say that that was in their power to do that, okay? That was in the court's power to do that, and that there's no merit in the state's claim that the US waived its rights to represent tribes because it led the state to believe that the barrier culverts did not violate the treaties, say, for example, by some sort of broader permitting process, which wasn't specific to, which didn't necessarily relate to, allowing salmon to run, or didn't consider that. So with that, we have this case laid out as I noted. This is a little bit different, right? It's different than other cases we've covered because we don't have an opinion to look to from the US Supreme Court. What we can do is go back to that Ninth Circuit opinion and look at that. And we can also look at the later denial by the Ninth Circuit for a rehearing en banc. En banc just means that the judges are just gonna look at it without all the other processes of having a trial or other parts of a hearing, requiring the injunction, which they had considered, which the state of Washington had asked for. So we can go back and we can look at those other opinions and sort of get a sense of this case. But I think what is ultimately pretty helpful is to look at to listen to the oral argument. All right. So I mentioned this before, and I'm just going to say this again, and I think this is a good thing to be doing every week. You've got a direct link to that in your MySBC. The court did hear the oral argument on both sides of this case, and its interests were, I don't know, I think they were a little bit unusual, but it's worth listening to kind of get the sense of why the Supreme Court might have split 4-4, right? Like why this might have happened. But as always, I am very willing to provide you with access or information in order to obtain your own access to these various parts of this decision, whether it be the amicus briefs or the even a transcript or the oral argument or whatever else you need. So feel free to get in touch with me for that, and we will see you, or I will see you on Wednesday night for our discussion group, and I'll have some questions posed by then, and we'll talk about those. And that'll be at 4:30 on Wednesday night. So have a good week and see you then.